called it genocide because it becomes clearer and clearer that Putin is just trying to wipe out the idea that he's able to clean Ukraine. And the evidence is mounting.
As President Biden calls Russia's actions in Ukraine genocide and vows to hold the Russian president accountable, a member of the U.S. Congress introduces a resolution calling on the United States to, quote, end its hypocrisy by joining the International Criminal Court. Hello and welcome to the program. I'm Ghida Fakhry. As President Biden calls for an investigation into Russia's military campaign in Ukraine, which he called genocide, some U.S. lawmakers say the United States must join the International Criminal Court if it is serious about making Russia accountable under international law. Democratic Congresswoman Ilhan Omar introduced last week a bill calling on the U.S. to become a party to the Rome Statute of the International Criminal Court, saying, quote, the U.S. is not party to the International Criminal Court, the principal body responsible for investigating and prosecuting these crimes. Our refusal to join the court is antithetical to our commitment to human rights, accountability, and the rule of law. Now is our opportunity to lead the fight against human rights abuses and support international criminal justice. Now, the United States is one of a few countries, including Russia, Ukraine, China, Iran, and North Korea, that have still not ratified the Rome Statute establishing the International Criminal Court. The ICC, which has 123 states parties, is entrusted with the prosecution under some conditions of war crimes, crimes against humanity, and the crime of genocide. The court, which has to date only indicted and tried nationals of African countries, has been criticized by successive U.S. administrations on the grounds that accepting its jurisdiction would expose U.S. military personnel to, quote, politicized prosecutions. Now, 2 years ago, the Trump administration imposed sanctions against the ICC's chief prosecutor, Fatou Bensouda, and other ICC officials following the court's decision to investigate possible war crimes committed by U.S. and other forces in Afghanistan. Last year, President Biden rescinded the sanctions, and the ICC has since dropped its investigation into alleged war crimes perpetrated by the U.S. military in Afghanistan. So can the U.S. argue in favor of international law and justice in the case of Ukraine if it refuses to become a state party and even threatens retaliation against the ICC? Joining me now is Alberto Gonzales, who served as Attorney General under George W. Bush. Attorney General Gonzales, there is a move right now, as you know, to rethink the U.S.'s position toward the ICC. A small group of Democratic lawmakers want the United States essentially to lead by example. The vast majority, on the other hand, of members of Congress, both Republicans and Democrats, want the court to hold Russia accountable for its actions in Ukraine while remaining outside the ICC. It was your boss, President George W. Bush, who reversed President Clinton's decision to sign the Rome Statute. I suppose you are still opposed to the U.S. joining the court, or have you changed your mind?
I still am of the view that the United States of America should not be a party to the Rome Statute, to be supportive of the ICC as a general matter with respect to jurisdiction over the United States.
Why not?
We believe that there are, well, for example, there are flaws in the operation of the ICC. For example, the prosecutor is totally independent. It's free to use whatever processes and procedures, and it could become a politicized process, quite frankly. In addition to that, certain safeguards that exist for Americans under our Constitution wouldn't be recognized necessarily in a trial or investigation by the ICC. So
isn't that what justice is all about? To subject yourself to the rule of law, to allow a prosecutor to use whatever tool at their disposal to conduct a proper investigation?
Oh, absolutely not. Every prosecutor, certainly every prosecutor at the Department of Justice, is bound by the limits of the Constitution. Certain rules are not admitted into evidence because of the rules of evidence. And so, no, the rules apply, and our prosecutors are not free to do whatever they want to in order to get the answer to the question, the indictment charged against a defendant. And so that we do have some serious challenges and concerns, and they're
But
bipartisan.
hold on, but they're free to pursue whatever evidence there might be. I mean, the main argument at the time for President Bush, and you were critical to that reasoning as White House counsel and later Attorney General, was that joining the ICC would make US military personnel the target of politically motivated trials. I mean, this argument could apply to any other state party. Wouldn't you agree?
Well, listen, if you give me an example where the United States of America annexes part of Canada or Mexico, and we do so on the basis that because we believe that there's Nazism there, and we start torturing and killing innocent civilians, then I might agree with you that perhaps there ought to be some other way to hold the United States accountable.
Well, I'll give you an example where the United States launches an invasion of a sovereign country, Iraq, on a faulty premise that there are weapons of mass destruction, which there weren't, in contravention of the UN Charter, and the Secretary General at the time said so, in violation of international law. That's a clear example, isn't it? That's a war of aggression. Well,
but there the situation is totally different in the way that the war is conducted. There we had the military following the rules of engagement. You had the military following the rules of the Geneva Convention. We weren't killing innocent civilians.
No, hold on. You know that isn't true. You know that isn't true, Attorney General. I mean, you know that there were cases where U.S. military personnel killed innocent, unarmed civilians. You have Fallujah. You have, hold on, Attorney General. You have Abu Ghraib. You have Haditha. You have countless.
Sanctioned by the United States government.
But no one was held accountable.
Sanctioned by that wasn't U.S.
No one was held accountable. Shouldn't the U.S. be also subjected to international law like any other country? Because it's all well and good to ask for justice in Ukraine.
The United States,
but what about justice for others?
The United States can certainly agree to be bound by certain tenets of international law, but it can choose not to, just like any other country. And again, this was not just about the Bush administration. There was bipartisan support for the decision for the United States not to become a party to the Rome Statute. So again, don't focus solely on the Bush administration. Bipartisan support that this be the position of the United States, and it's remained that way through various administrations of both parties.
The truth, though, is, Attorney General, that U.S. forces and military personnel and contractors have committed alleged war crimes. The U.S. has practiced what the entire world deemed to be torture. In fact, even President Obama called it torture when he said in 2014 that, quote, "we tortured some folks." He put an end to these so-called enhanced interrogation techniques, in plain English, torture. Again, a program that you had justified, you had authorized, arguing that the war on terrorism was a new kind of war. And therefore, the tenets of the Geneva Conventions were obsolete.
What happened in the Bush administration when we've got the systemic torture and killing of thousands of innocent civilians, not just a handful, maybe not even just hundreds, but thousands of civilians in Ukraine. I don't understand why we are relitigating what's happened in the past and comparing it to what is happening today. What we're discussing now has nothing to do with the ICC.
I'll tell you why, because isn't it completely absurd, and many would say hypocritical, for the United States to say that war crimes should be referred to the ICC, war crimes committed allegedly by Russia, perfectly well, to make the argument, absolutely, but shouldn't the same apply to other countries as well?
The ICC in the judgment, I think, of the U.S. government was that it wasn't intended to prosecute every international crime. It was intended to prosecute the most serious of international crimes, like we're seeing in Ukraine. And again, the issue that I think that I hear you saying is that it doesn't matter the level of crime. It doesn't matter who's making the accusation, that everything should go to the ICC. That was never the intent, as far as I understand. And other former and existing government officials in the United States, they take the same position.
Whether or not Russia is referred to the ICC for its alleged crimes in Ukraine, can you truly conceive of a rules-based international order where there's one standard of justice for some and another for others? I mean, can we have a rule-based international order based on what looks like a caste system, except that in this case, the untouchables are the powerful ones or those with powerful friends, like the United States, like Israel.
Well, I'm not suggesting that that people evade prosecution or they not be punished for wrongdoing. And that doesn't necessarily follow that people would evade justice. There would be different justice just because we don't belong to the ICC. I think it sounds like you're equating our membership in the ICC to be necessary in order for there to be equal justice. And that's just not true.
All right, former US Attorney General Alberto Gonzales, thank you very much.
The International Criminal Court is troubling to the United States. It's troubling to the administration, obviously troubling to the United States Senate as well. President Clinton signed this treaty, but when he signed it, he said it should not be submitted to the Senate, and therefore never has been, and I don't intend to submit it either, because it, as the United States works to bring peace around the world, our diplomats and or soldiers could be dragged into this court.
In 2002, then President George W. Bush vowed never to ratify the Rome Statute, which his predecessor Bill Clinton had signed. Since then, the refusal to join the ICC has extended to both the Republican and Democratic parties. A few months after the establishment of the ICC, the U.S. Congress passed the so-called American Service Members Protection Act, which authorized the president to use all means necessary and appropriate to bring about the release of any U.S. or allied personnel being, quote, detained or imprisoned by, on behalf of, or at the request of the International Criminal Court. It also prohibited U.S. military aid to countries that joined the ICC unless they were members of NATO or were major non-NATO allies or had agreed not to surrender U.S. personnel to the court. My next guest is a former U.S. official who helped draft a provision of the law giving a president the authority to take specific actions to help the court. John Bellinger served as the legal advisor for the U.S. Department of State and the National Security Council during the George W. Bush administration. John Bellinger, when you look back at the decision of the Bush administration not to ratify the Rome Statute, in hindsight, was it a mistake for the U.S. not to join the ICC, and is it time for the U.S. Congress to review its policy toward the court?
Well, personally, as an American lawyer, as the former legal advisor for the State Department, I would like to see the United States be part of the International Criminal Court. The United States has always been at the forefront of international criminal justice. We've helped many international criminal tribunals going back to Nuremberg, but really, by the time the Bush administration came in, it was too late because the treaty that was created, the Rome Statute that created the International Criminal Court back in 1998, had not addressed the concerns that the Clinton administration had. So the United States actually voted against the treaty that created the International Criminal Court back in 1998. And although President Clinton later signed the treaty, he said he wasn't going to send it forward to the Senate. So really at that point was not so much the Bush administration's decision, but a decision that had already been made. There's been bipartisan concern through Republican and Democratic administrations about the International Criminal Court.
Well, both parties, one could say, are equally to blame for staying outside of the ICC. But today, when you look at the growing calls within the United States, there was just recently a resolution passed unanimously by the Senate praising the ICC, encouraging member states to refer the situation in Ukraine to the court. So it seems that the court is useful to the United States when it can advance its interests. But isn't there, in the words of Congresswoman Ilhan Omar, a glaring asterisk over any calls for justice made by the U.S. as long as it advocates one standard of justice for itself and another for other countries?
Well, I think many Republicans and Democrats have always said that the International Criminal Court performs a useful purpose and that we are prepared to support the court when it is doing the things that it was set up to do. Unfortunately, over the last 20 years, the court has often gotten off track. And the concerns that the U.S. has had in both Republican and Democratic administrations have continued. In the case of Russia—
Hold on. You say it's prepared to support the court, but not to subject itself to the rule of law. under the court. And when you say it's gone off track, why has it gone off track? Is it because there was an investigation that the ICC chief prosecutor wanted to open into potential war crimes that were committed by US military personnel in Afghanistan? Is that a reason why you would say that it's gone off track?
Well, that's not the only case, but that is certainly one case. The United States did have concerns about the investigation that was launched by the previous prosecutor into alleged war crimes by the United States in Afghanistan. The United States felt, one, that because it wasn't a party to the court, that it should not be subject to the court's jurisdiction. But more important,
but that is exactly, but hold on, that's exactly the statement and the argument that Russia makes. It says it is not party to the statute, therefore the ICC, any referral to the ICC shouldn't apply to it. Same statement, same position.
I think that argument that the United States should just not be subject to the jurisdiction of the court at all is too broad. An argument that I recently made in the Washington Post is that if you simply apply the terms of the treaty itself, that it would not apply in the case of the United States because the United States does investigate our own war crimes. That's the difference between the United States and Russia. Russia claims that it has done absolutely nothing wrong in Ukraine, while it is clearly bombing hospitals, civilian areas, and committing acts of rape and murder. But the difference is that the United States actually investigated each of these cases. The difference is not in the result, it is whether the United States actually investigated the cases.
How can you say it's not in the result? Hold on. How can you say it's not in the result when what you're trying to achieve here is justice for Ukrainians, which is well and good, but don't Afghans, don't Iraqis and others deserve justice? How can you say that the result isn't important?
So I think anybody can see the difference between what Russia is doing in Ukraine, committing war crimes all across Ukraine by bombing civilian centers, bombing hospitals, occupying areas, raping, committing murder. There's a big difference. Yes, the United States has certainly, there have been offenses, there have been investigations. No one is saying that the United States is actually a perfect country, but the Rome Statute was intended to complement the jurisdiction of national authorities. It's not a court of first instance, it's a court that steps in when a country has not investigated.
We'll have to leave it there. Mr. John Bellinger, former legal advisor to the U.S. Department of State and National Security Council under George W. Bush. Thank you very much. Now, earlier this month, President Biden labeled the Russian president, quote, a war criminal and called for a war crimes trial.
There's nothing less happening than major war crimes. Responsible nations have to come together to hold these perpetrators accountable.
Since then, the U.S. president has used the word genocide, echoing his Ukrainian counterpart. The U.S. is one of 152 state parties to the 1948 Genocide Convention, an international treaty that compels state parties to take action whenever genocide is deemed to have occurred. While the ICC can prosecute the crime of genocide, the crime of aggression, as defined by the UN Charter, does not fall under its jurisdiction. Philippe Sands is a professor of law and director of the Center on International Courts and Tribunals at University College London. He's also a visiting law professor at Harvard University. Professor Sands, for the past 20 years, the ICC has been conducting investigations into war crimes, crimes against humanity, and genocides. So far, you have about 123 countries who've joined the ICC, not Russia, not the US. Ukraine, though, has granted the ICC jurisdiction to prosecute alleged crimes committed on its territory. 40 member states, at least, have referred the situation in Ukraine to the ICC. But when you look at the situation today, Russia, just like the United States, has always argued that the ICC cannot prosecute nationals of a state that has not joined the court unless the UN Security Council refers the situation, and we both know that that won't happen. They both have a veto. Is the ICC investigation then into alleged war crimes likely to lead anywhere given this reality?
Well, hello, it's terrific to join you, and you're very right to focus on the International Criminal Court, which sits in The Hague. The International Criminal Court has got jurisdiction over any of the crimes that you've mentioned that are committed on its territory after 2014. And that jurisdiction extends to crimes committed by any person of any nationality. So the argument that it would not have jurisdiction over a Russian because the Russian state is not a part of the statute is a nonsense. That is pretty well established. So it has jurisdiction, and it is now exercising that jurisdiction. Investigations have begun. You'll have seen images of the prosecutor traveling to Ukraine, meeting with Ukrainian investigators. And my understanding is that the focus is on war crimes and crimes against humanity. And yes, Russian nationals are in the frame, from the soldiers on the ground who are alleged to be committing abuses, right up to the commanders at the top under the theory of command responsibility. So in principle, Mr. Putin himself falls within the jurisdiction of the ICC.
But many, as you know, here in the US have argued that this war that the Russians waged in Ukraine is illegal, might very well be, obviously, and there is much to say about the alleged crimes that are being perpetrated in Ukraine. But by the same token, does the same apply retrospectively to the crime of aggression committed, the illegal war committed in Iraq?
Sure. Well, it's a very, very important question. The crime of aggression occurs when a war is manifestly illegal. This one plainly is. There's no justification in self-defense. It was not authorized by the Security Council. It is not justifiable on humanitarian grounds. And of course, in my view, the same principles apply in relation to Iraq back in 2003. I thought that was a manifestly illegal war. And some people in very senior positions called it a crime of aggression. The Deputy Foreign Minister, Foreign Office legal advisor in London, Elizabeth Wilmshurst, resigned because of the war in Iraq, and in her resignation letter, which lately became available, she said that this is a crime of aggression. I cannot participate in this. And many people, I think that. So I think, yes, in principle, that too ought to have been investigated. But at that time, the politics were not ripe for creating any sort of a special tribunal. There was no other tribunal that had jurisdiction. And in a perfect world...
Is it important for the US to become a full-fledged member if it wants to dictate the way the law applies to some countries and not to others?
Well, of course, I would like to see the US to be a member, but one of the things that brought a wry smile to my face a few weeks ago was a resolution that went through the United States Senate, proposed by Senator Lindsey Graham, supporting the ICC investigation of Russians. A break, if you like, with Mr. Graham's traditional position. That resolution sailed through the Senate, passed unanimously, and all of a sudden, if you like, the US claim that its nationals should not be subject to the jurisdiction of the ICC is under very significant attack. I think what we're looking for is rules of international law, rules of international criminal law that are applied equally and evenly above to all participants, irrespective of how large, how small, how powerful, how weak they are. We don't want a lopsided international justice. We don't want a system of international law which is for others, but not ourselves. But that aspiration remains, I think, some way away from being achieved. But it is what we must aim for.
All right, Philippe Sands, great to have you. Thank you very much for being with me.
A pleasure.
For the past 20 years, various US administrations which have professed that no one is above the law have had a strange relationship with the International Criminal Court, the only permanent court to prosecute war crimes, crimes against humanity, and crimes of apartheid and genocide. Washington believes the ICC is beneath the US and its judicial system, and that it may be biased against it. Yet, it deems the court good enough to investigate and prosecute crimes perpetrated by others, with just two exceptions, itself and Israel. The US went as far as slapping sanctions on the ICC's chief prosecutor, Fatou Bensouda, in 2019, after the court opened an investigation into alleged war crimes in Afghanistan. That followed an earlier probe into alleged war crimes in the occupied Palestinian territories. Now, the few and rare voices in Congress that call for the US to join the ICC, primarily to allow the US to hold or gain a moral ground, are very unlikely to succeed If there is a common currency deeply held by both parties, it is so-called American exceptionalism. And so in short, if justice means, in essence, that no one is above the law, then international law and international justice operate on the same premise. International law and therefore international justice can only find true meaning if their jurisdictions are universal, if their credibility is rooted in one set of rules for all, and not the double standards we've been accustomed to for far too long, and which continue to show their limitations and sow more conflict, more violence, and more violations of international law. That's all from me, Ghida Fakhry, and the team here in Washington. Thanks for watching.